Paul,
Yeah.
I was reading this law dictionary. There's a bug right there. This is they have what's called treble costs, an award made according to an existing statute, wherein the person receiving the award gets the ordinary costs, then half of the ordinary costs, and finally half of the latter costs. And then there's treble damages, an award of damages according to existing statute consisting of the actual damages tripled. A jury usually awards merely the actual damages and the judge triples them. This large award is sometimes given as punishment to the defendant, but in other cases is awarded solely because the law in the matter calls for treble damages. Now, they have what's called a trial, a fair and impartial trial, a trial characterized by an impartial judge and or jury, one in which all evidence is heard before a verdict is reached. In such a case, the defendant's rights are safeguarded and he is represented by a competent attorney. Then there's a trial, a proceeding in a court to decide a controversy. A trial may be for civil action or criminal action. Now, as much as you wouldn't want to think of a protection order as being an actual trial, the court finds, based upon the court record, that the law requires the order to say the respondent had actual notice of the hearing and by what method. I had pointed out yesterday that when you accuse me of domestic violence and you accuse me of child abuse, and I'm not given notice and opportunity to be heard at a court trial where they issue a protection order, it's a type of judgment. Now, every court hearing is a type of trial, and the court finds based upon the court record. Now, when you do not give actual notice and opportunity to be heard, and the court decides the civil matter based upon the court record, then it's obvious that the trial, the court hearing, did not judge according to what the law requires. Now, the judge can grant, deny, or change any provision you write in this order. The judge will complete the shaded box about jurisdiction over the minors. Although the judge will fill out the provision, it is important for you to think about what visitation you want to recommend for the respondent to have with the children. For example, no restrictions on visitation, supported visitation, or no visitation pending compliance with treatment or counseling. Now, to obligate me to have a mental health evaluation when you had a court trial where the commissioner could have been prejudiced about the issuance of the protection order. And then I emailed those in law enforcement that the protection order violates the Domestic Violence Protection Act, violates the Violence Against Women's Act, yes, violates the amendments in the Constitution, yes. And then they refuse to remove it because they just can't accept that they could have made an error. Now, when I got arrested on January 4th, for this violation of a protection order, where I had informed law enforcement that it's against the law to issue a protection order that isn't issued according to the federal legislation called the Violence Against Women's Act. And then they continued to make me go to trial. I'm looking at some damages that could be far excessive of triple damages. They might want to teach the defendant any city that would not enforce the laws of the United States, any county that would not enforce the laws of the United States, any state that would not enforce the laws of the United States. Now, when I email sheriffs in other counties that this is illegal, and they tell me, well, it didn't happen in our jurisdiction, they have to enter this into the law enforcement data entry. The order will be entered in the statewide database used by law enforcement, so any officer in the state knows of it. The name of the agency which has jurisdiction over where you reside. Now, the thing is, if I were to go to any county, once it's entered in the WACIC, and it's an illegal protection order because it did not get issued according to the VAWA. It did not get issued according to the instructions from the state of Washington. It did not get issued according to the federal legislation called Domestic Violence Protection Act. And then it goes from the WACIC into the National Crime Information Center, where it's enforceable in every county of the United States. And the sheriff tells me that they don't have to enforce the laws. Well, once it's in the national database and it was issued not according to the law, but according to an error of judgment of a county commissioner, they are all liable because they have the knowledge that the order violates numerous federal legislations, the United States Constitution, the constitutions of their respective states. And when sheriffs of other counties don't realize that once it's in the NCIC, and if they ever got a phone call that I had violated it, they would have to enforce what is an illegal court document. Now I'm going to need to know the employees of every municipal utility everywhere in the nation. I'm going to want to know every sheriff that's been using electricity without paying for it. Any and all municipalities that have done anything to the water supply other than what is just legally allowable for. And all the sewer districts, I notice quite a bit.